citizen in use common sense in matters such as this. We'll conduct our meeting with decorum, respecting the important matters we're addressing. And we know that this is a stressful time for everyone involved, and we try to make this experience a learning experience as much as possible. We are not a court of law, and the matters that we discuss are not illegal or criminal in nature, the matters we're discussing today. They may be lapses in judgment, unintended, they may be simple failure to follow the charter or the code of ethics, or in this case, the bylaws of the Board of Education. Quite often, what we determine is that while an ethics offense has occurred, the respondent may not have been acting out of malice or self-interest, but simply didn't know that he or she may have done something that was an ethics offense. And so we do try to make it a learning experience. Since 2008, we've received over 70 complaints, and we've found a probable cause hearing. We found the reason to schedule a probable cause hearing only 11 times, so it's unusual for us. This is a meeting conducted in public, but there is no public comment or participation of any kind. And at all times, members of the public must be quiet and respectful. And I'm going to just go through very quickly how we're going to proceed with the hearing and what our purpose is. Our role is to gather facts of the hearing, and we've been doing that, but we will solidify them today, and then to make a recommendation to the Board of Selectmen. The Board of Selectmen determines the final outcome of the complaint. We don't. But their decision has to be consistent with the facts that we find. All witnesses will be sworn in, and I'll ask Attorney Beecher to swear them in at this moment. So anyone who will be speaking for either party, please stand and raise your right hand. And, Attorney Beecher.
Yes.
What?
Do you all solemnly swear or affirm, as the case may be, to tell the truth and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Once we begin the hearing, that'll start very soon, the Board of Ethics members may ask questions at any time or make comments at any time. We will first turn to the complainant, who will present his complaint, and the respondent will be provided time to question the complainant or any witnesses that the complainant may have. Then we'll turn to the respondent, who will present her response. The complainant will be provided the opportunity to ask questions of the respondent or any of her witnesses through the chair. And we try to do the questions through the chair so that it's not a back and forth between the parties. Once we conclude that part of the investigation, the complainant and respondent will remain silent unless specifically asked for comment by the Board of Ethics. So after we've heard from both parties and any witnesses, we'll continue the meeting in public, and the Board of Ethics will discuss the information that was presented today and that we've gathered previously, and we'll begin to develop our facts. We'll then discuss recommendations, and the range of recommendations may be found at the end of the Code of Ethics Ordinance, Section 7, Penalties. If we need more time to gather facts or discuss a recommendation or prepare our report for the Board of Selectmen, we'll make a motion to adjourn, and the hearing will reconvene as soon as schedules allow of the 3 members of the Board of Ethics. That meeting will be conducted in public. We will definitely have to meet once again to discuss and approve our final report to the Board of Selectmen, and that meeting will be posted and available to the public. Let's see. Once we submit our report to the Board of Selectmen, we have ended our charge, and the Board of Selectmen then takes over. I'm just going to go through a very brief bit about how this complaint has has come to be. In early January of 2025, we received a complaint that was filed in December of 2024, fairly late around Christmas. And the complaint was Andrew Correa versus Wendy Youngblood, Chair of the Board of Education. And we designated that as C2024-04. All that means is it's complaint year 2024 and the fourth complaint in that year. Once we receive a complaint, anything related to the complaint must remain confidential according to state statute 1-82A. We provided copies of that statute and to both parties. And throughout our investigation, any correspondence we receive or provide to either party is shared with the other one. So among the group, it's very open there. We've met on February 18th, March 20th, April 2nd, April 24th, and April 29th involving this complaint, all in executive session. All of those comments were all of those determinations were in executive session. We relied heavily on videos of meetings of the Board of Education, as well as analysis of various Board of Education bylaws, the charter of the town, and the Code of Ethics ordinance. At the April 24th meeting, we came out of executive session and determined that we had sufficient evidence to believe a violation of sections of the town charter or Code of Ethics ordinance may have occurred. That step does not mean that we determined the outcome of the complaint, but only that we had sufficient evidence to move to a complaint. Mrs. Temple agreed to draft the report of our findings from April 24th, and we next met on April 29th to approve the report and immediately sent it by certified mail to both parties. Along with our finding of evidence to determine possible probable cause, we did provide Dr. Youngblood with 6 possible dates and times for the hearing, and she selected this date and time. And that brings us to today. We've already received and reviewed the extensive documents provided by the complainant, and we recognize that today is really not only the opportunity for the complainant to discuss what he presented, but the opportunity for the respondent to provide whatever information or explanation she wishes. And all documents related to this complaint are available in the town clerk's office for public view. So that gives us a little bit of background of where we are. And I have asked Mrs. Templeton to basically spearhead the middle part of the hearing, so.
Thanks.
Good luck.
Thank you. All right, so we are convened today for an evidentiary hearing to determine whether the facts before us support by a preponderance of the evidence, that is, whether it is more likely than not that a violation of the Brookfield Town Charter and the Code of Ethics occurred. Specifically, we are here to address 2 allegations: whether the respondent should have recused herself from deliberating and voting on a complaint filed against her, commonly referred to as the 1312 complaint, and whether the respondent was obligated to step away from the board table during that deliberation as required by the Code of Ethics, given her direct personal interest in the matter. The core questions before us are: did the respondent's involvement on that November 20th meeting present a conflict of interest? And if so, did the respondent take or fail to take appropriate action in violation of her ethical obligations related to that conflict? This hearing is an opportunity to receive evidence and testimony that we haven't already received relevant to these allegations, both in support of and opposition of the claims made. Before we proceed with the complainant's presentation, I want to clearly establish the purpose and scope of this proceeding. This hearing is not a forum for airing personal grievances, making character judgments, or raising unrelated criticisms of the individuals involved. The Board of Ethics is charged only with evaluating potential violations of the Ethics Code and Town Charter based solely on the allegations and facts tied to the events that occurred at the November 20th, 2024 Board of Education meeting. We will not consider speculative remarks or commentary on matters beyond the scope of the complaint. Any such comments may be ruled out of order. Our responsibility is to conduct a respectful, focused, and fact-based review consistent with the legal and ethical standards that govern our work. Again, we're here to only discuss the November 20th, 2024 Board of Education meeting and whether the respondent's involvement presented a conflict of interest, and if so, did the respondent take or fail to take the appropriate action. So with that said, I will invite Mr. Correa to present his case, and I have a question for you first.
Sure.
We can get started. I'm wondering how you're planning on presenting your evidence as it relates to the questions provided in the complaint.
So, I submitted a complaint, of which is a public record that you reviewed.
Yeah.
We could play the video if you have it available, but I was going to discuss what was in the complaint. And I would like to ask questions of witnesses, what
Okay.
they saw. Okay? So, like, a relatively brief summary of the complaint that you, have annotated in the probable cause finding is that, on November 20th, at Board of Education meeting, there was a public complaint against the chair, respondent, Wendy Youngblood, about whether she had, essentially the complaint was, there was a meeting that was unfair. The board, needed to decide whether to take up the complaint and then adjudicate the complaint. The actions underlying that was in the complaint, it being unfair, violated Board of Ed policy regarding whether the chair should or how a person from the Board of Ed would meet with a union official. So when the chair presented the agenda item, she was essentially asking the board if they would consider a complaint against her conduct, of which she would have a direct personal interest in presenting that particular agenda item. She stated she would recuse if the board determined that they would hear it. So deciding whether you were going to recuse based on your conduct and not recusing, those two issues are, there's a difference of that, there's no distinction of the difference. So Ms. Youngblood polled the board and asked who's ready to vote and said, I'm ready to vote. And as you saw in the video, she voted to not, for the full Board of Education, to not hear about a public complaint about her conduct, of which the discussion would reveal that she broke Board of Ed policy. After she declared that she had a conflict and was going to recuse and handed over the chair to the vice chair, she remained at the table, the deliberation table, and you can see that in the video, publicly available video. Contrary to the requirements of the Code of Ethics. And through the discussion, there were a point of order raised, of which there was a question, and Ms. Youngblood said, you can't discuss that here. So she essentially ruled on point of order. And then there were several votes, the motions and votes, there was about 3 of them. And one of them was related to potentially asking her to step down as chair or remove her as chair. The actual vote wouldn't have passed to remove her as chair because of the policy, but asking her to would be up to her. But she gave testimony. She endorsed the prior speaker, who was the vice chair, stating what her opinion was of the matter. The vice chair, Rosa Fernandez. And when the Youngblood made an appeal while she sat at the table. Now, it was inappropriate for her to speak in that meeting at all. She should have been in the audience, the Code of Ethics. If the board wanted to hear from her, then she could have come up to the podium and explained why she was in the meeting, if she understood her obligations as it relates to the Board of education policy. She was confused who was with her. Throughout the whole deliberation, she did not mention that, who attended the meeting. So there was clear, plain on its face violation of the Board of Education, of Board of Ethics rules. And it wasn't the first time this has occurred. It has occurred several times. For items I don't think really, they didn't rise to the level that a Board of Ethics complaint would, it makes sense. However, it was pointed out that she should not sit in deliberation, multiple times. Subsequent to that meeting, I sent an email to the board laying out precisely what is in complaint C-2404, asking them to address it on their own, like to come out and state that it was inappropriate, it shouldn't have sat at the table. Ms. Youngblood didn't do that. Instead, what she did was she conferred with the attorney I sent the email on December 3rd. She conferred with the attorney on December 4th and didn't address it until she received this complaint. And then she conferred with the attorney on January 13th. She's had 4 months to come forward and say, like you had mentioned, we're members of the public, trying to do the best for Brookfield. If it was clear that she should have acted differently, she's had 5 months to come forward and say, really, I should have handled this differently. So.
If she had come forward and said that, what would you have?
I wouldn't have submitted this as a complaint. And one of the reasons why I've submitted this as a complaint was because there's several issues where she was acting unilaterally. There's also issues within the school. The core of this particular meeting with the union representative, comes to the actual behavior, right? So there were climate surveys among parents and staff. They were generally good throughout the district. They were really bad for staff at CLES. And the actions of the board to try to address it were bifurcated. There were 3 members that were trying to ask questions.
Sorry to interrupt, but does this have anything to do?
Yes, it does.
Okay.
It doesn't. So,
In what way? I'm sorry.
control of information. So if you're sitting at the board table trying to quell a complaint against you, and the underlying meeting was with the union president who was upset with how the board had handled the climate review survey, and she's assisting that union representative in quelling that. It's the underlying, the problem is the underlying management of the board, of the school district, is being undermined by her approach.
That sounds like a bigger issue than
It's
just
all
the
ethical.
November 20th meeting. I know you're saying it's all related, but I'm saying we're here to just discuss whether she should have been at the table, essentially.
She should not have been at the table, and she should not have voted as to whether the board would or would not receive the complaint. And in fact, Rosa Fernandez shouldn't have been there either, right? They were both at the meeting. They should have trusted the other 5 members to decide, should we take up this complaint? And if 5 members said we don't want to take it up, then there would be no issue, right?
Got you.
And if they decided to take it up, what likely would have happened is they would have decided to take it up. What likely would have happened was a more open discussion of what the actual requirements were of the Board of Ed and why it was inappropriate for her to meet with the union rep.
Got it.
Right? There's a reason why one person can't just meet with a union rep. You don't want them to make a commitment on behalf of the town on a contract.
I
There's a ton of
understand that
reasons.
is the subject matter of the 1312 complaint.
Yes.
And
if you behave in that way, and the public should be able to complain. And if, members of the board are gonna, come together behind the back of other board members to have a meeting anyway, and then show up at the board meeting when there is a public complaint, and decide to sit and vote in an issue of which they have a conflict, that's a problem.
Got it. Okay. So regarding the 1312 complaint,
Mhm.
what, we're not here to deliberate as to the, you know, the merits or anything else really, except to the extent that it's related to this alleged conflict of interest. So,
The point of the 1312 in the underlying is the public should be able to complain, and if they do, they should expect the board to comply with the Board of Ethics and Code of Ethics and recuse themselves. And the underlying complaint is that essentially that Wendy and Rosa violated Board of Ed policy and stay for a reason.
okay. So regarding that complaint,
Mhm.
can you tell me what, it sounds like she was the direct, essentially the respondent in that complaint.
To 1312, yes.
Yes. Do you know if there's any motivation for monetary gain arising primarily from her interest there, or any other, what do you think?
I think it's affiliation to support educators, okay? And the concerns of the union rep was that 3 other board members were asking questions at the Board of Ed that they didn't like. And so that subverts governance of the Board of Ed to manage the district. The questions were, so because there were climate issues, there was a climate plan to improve climate, and it was not very, it was obviously not very impactful. It was having, listening sessions and a rolling desk, and members of the board that were asking questions like, how do you ensure, should we have another survey, things like that. And it was somewhat contentious among the board. And there was also another issue where the members of the Board of Education were asking members of the administration and teacher questions about a presentation as it relates to school curriculum specialists, and whether they should continue to have curriculum specialists or formulate it a different way. And part of the complaint from the union president was that the discussion was disrespectful, and the disrespectful part was follow-up asking if they brought data they promised to bring the prior presentation. So overall,
I just wanna stop you a second. You're really going far afield.
not really.
No, listen, you're going far afield from what we're here to talk about. And it's a very,
She asked me if there's
no.
where the conflict was.
No, it's a very specific, narrow focus. You're going into climate and the union and what, no, what the teachers are interested in or concerned about. That's not why we're here. So,
Yeah, the conflict is,
no. Okay,
That-
I want you to focus on.
yeah, I'll tell you what the conflict is.
All right,
The conflict is she was acting more on behalf of the union against her own board members when they could have that discussion openly at the board,
And that's what the complaint was about.
essentially.
Okay,
Yeah,
got it.
because there was another board member who asked to attend the meeting. Okay?
I did
And that member
see
was
that video.
blocked out, okay, and that member was one of the board members that were asking questions. Now, Ms. Youngblood and Ms. Fernandez sit on a personnel and negotiation committee of 3 people, okay? The third person was Joy Greenstein that was asking to go.
Mhm.
They were on emails with
But this doesn't have anything to do with the vote, right? Or
it
the-
has to
the
do with blocking her
deliberation.
out of the meeting, And so, if
Well,
she-
we're just here to determine whether she should have been at the table or not.
yeah,
Right.
and she shouldn't have, because it was about her being in a meeting violating Board of Ed policy.
Got it.
first of all, that's not a fact, that's your opinion. And we're not really interested in opinions at this moment.
It's a fact she was at the meeting, it's a fact it violates Board of Ed policy.
That's a fact.
Yeah.
but the reasons for it are your opinion, and that's not our role. We're just concerned with, should a board of any Board of Education member have, participated in discussion on a conflict of interest charge and stayed at the table. That's what we're here to talk about.
So,
We have not looked into any matters concerning anything that might have led up to it.
Okay.
That's not our charge.
so if there's a complaint against her,
Yes,
she brought it up for a vote at the table
yes,
and voted not to hear it.
that,
And if there was a complaint against her, there was some personal interest that she could be reprimanded, it could just, even if you vote against hearing it, then you're saying, I don't want the public on video to see what happened to that meeting. I don't want the rest of the board to be able to discuss,
which is also a supposition on your part. It's not a fact, it's your opinion, that's what the motivating factor was.
well, she was going to recuse if they listened to it.
What, excuse me?
She had stated she would recuse from the deliberations if the board voted to hear it. So how can you have a conflict in the matter, but not a conflict in whether the matter is heard?
That's relevant.
Okay,
Through you, Madam Chair, can I just ask one question to sort of flesh out a fact that Mr. Correa stated?
do you have the code of ethics?
Yes.
Yeah.
Please.
You mentioned that the respondent consulted with an attorney at least once, maybe twice, I think you just said today.
Yes.
Can you just tell us who that attorney was?
I believe it was Peter Mayer.
Is he a Board of Ed attorney?
Yes, he is.
Thank you. That's all I wanted.
So Peter Mayer, she would, conferred with Peter Mayer for 1.2 hours on December 4th, which was the day after I sent an email telling her exactly how she broke the Board of Ethics and asked her to fix it. And then they spent like 4 hours between Peter Mayer and then another lawyer for Shipman and Goodman on looking at the issues.
Thank you.
And so what I'm telling you is I think at some point in time, she should have said, yeah, I should have been open with my board. I should have not sat at the table when the original 1312 came up. And then just, take the advice and consequences from my peers.
Can I ask you, Mr. Correa, is there any question that the video is a fair and accurate representation of what happened? That's the premise that we're going on, and it seems that way.
I mean, I don't know how anybody would be able to, manipulate the video, the power didn't go out.
Yeah.
Sometimes it does, right? The power didn't go out that day. It's been on YouTube. It's not, a deep fake.
I believe it does, but
Yeah.
I
I
just
think
wanna get your opinion, and Ms. Youngblood, do you agree that the video is a fair and accurate representation as to what happened
That's what occurred.
Okay, so we have all of those facts.
Yep.
And we've seen all the video.
Mhm.
So with that in mind, is there any other witness or information you wanna provide us to testify of something that's not in the video and something that we don't know already?
So it was in the complaint, you have access to the video. 3 weeks prior to that meeting, the Board of Education had training on conflicts of interest, including going through pretty deep examples about when one should or should not
I saw that.
recuse.
Mhm.
And in fact, it was quite humorous, some of the examples that were brought up, and everybody laughed and nodded their head that they knew, if you have a brother-in-law that can fix an oven in Thanksgiving, that you shouldn't sit in a deliberation whether to hire that person, right? That is a personal conflict
I
of
saw
interest.
that, yeah.
So if you can hire your brother-in-law that can, fix an oven, right, can you sit in deliberation when there's a complaint against you? And then the other question is, if you declare you have a conflict, the code says you can't sit there. she declared she had on the second
I
vote.
heard that, yes.
Right. And you're also not supposed to discuss anything. She weighed in on a point of order, and then she testified without being asked.
Got it.
So that definitely influenced the discussion and vote.
So, thank you. I think we understand and know all of those facts and have seen the video a few times. So with that in mind,
I did want to ask questions of Ms. Devine and Ms. Scalera, if possible.
sure.
I'm sorry, who are these
It's
people?
all stuff on the video, but stuff.
Just,
Mr. Correa, I'm sorry, who
Oh.
are these people you're?
they're members of the Board of Education.
And who are they?
They're Sarah Devine and Aaron Scalera.
Sarah Devine?
Yeah.
And which
Aaron.
one is Sarah Devine? You? And who, you are?
Aaron Scalera.
Aaron Slater? Thank you.
I have the same questions for them. Do you want them to come up here or?
So to the extent it will add new information, just.
Yeah.
Again, Rick.
I just want to ask them, I guess,
Yeah.
You wanna go? Go.
It's for the recording.
Oh, is it this one?
So-
Is this it? The mic's not working? I don't know.
Podium one.
you can talk into that one.
Okay.
So, were you at the October 30th ethics training with
Yeah.
Tom Mooney?
Yeah.
Was it clear what board members' recusal duties are through that discussion?
Yes.
Based on what occurred on November 20th, was it clear through the training that Ms. Youngblood should have recused?
Yes.
And was it clear that you have to leave the table?
Yes.
And was it clear through that training that you have to recuse yourself entirely from the issue?
Yes.
Okay. Before it was public, did you know about the September 26th meeting between Ms. Youngblood, Ms. Fernandez, and the DEA PEA president?
I knew that Ms. Youngblood went, but I only found out through the FOI, that Ms. Fernandez also went.
Okay, and when she sent you the email recapping the meeting, did she state who the attendees were?
No.
No? Okay.
Well, I believe she said I met with Mr. Petrino.
She didn't say any other
No.
attendees? Okay, and what would be the correct procedure for a member of the Board of Ed to have a discussion about interactions with the Board of Ed, with somebody from the union?
Well, it's my understanding that she wouldn't go by, no one would go by herself, she'd go, the whole board could be.
I'm sorry, I can't really.
I believe, can you repeat the question?
So what is the correct procedure for a member of the Board of Ed to meet with the union president if there was a concern about board union interaction?
I don't know if I have the exact facts, but I know that it wouldn't be one person meeting, it would be on behalf of the whole board would meet, or, it would be the full discussion and full, transparency on what the discussion is,
And did that occur?
not at all.
I have a question. At that meeting, that we're talking about, the November Board of Ed meeting, did you raise any of these issues specifically with, Dr. Youngblood or anyone else on the, did you mention about conflict of interest?
At the time,
Yes,
no.
why not?
I don't know if with everything going on, it wasn't something that, that I thought to stop and kind of stop what was going on. It was kind of all happening pretty quickly.
I watched that, and there wasn't much specific information from either side presented concerning the vote, one way or the other. There was more emotion, it seemed.
It was sort of a coercive chair.
I'm not talking to you. And I'm just wondering why that didn't happen. Why didn't you just, cite board policies, bylaws? It's in the bylaws. Just didn't come up.
Yeah, I didn't think of it at the time.
Okay, thank you.
Aaron?
I don't know if you,
while she's signing, it did come up, Ms. Greenstein did say that she asked to go to the meeting, et cetera.
I'm not interested in
Sorry,
what
it's
they
not-
did.
It's not my opinion, it's in the
I'm not-
video.
I'm really interested in what they did.
Okay. So were you at the October 30th training with Tom Mooney?
Yeah.
Was it clear what the recusal obligations are for Board of Ed members?
Yes.
Based on what had occurred in the November 20th meeting, should it have been clear to Ms. Youngblood that she needed to recuse?
Yes.
Did she recuse?
No.
Did she vote on an item that she, about?
Partial,
Okay.
I mean, I'm gonna be honest, I have not revisited that meeting since
Can you come
November.
closer to the microphone?
I haven't revisited that meeting since, we had the meeting, I haven't reviewed any of it.
Can you explain your response as partial?
I think there was I think there was a vote and then a recusal, is from what I understand. Like, were we voting to hear it, to bring it forward, were we gonna hear the complaint? I believe that, there wasn't a recusal at that point, and then there was a recusal after that, so.
At what meeting was this?
That's
The
right.
meeting of the 20th, there was information on the recusal?
Well, I think she did recuse herself after it was brought up, after we decided whether to, listen to the vote or not. Or listen to the complaint or not.
And you
Here.
were aware of board policy on the matter?
Well, I mean, we all have access to board policy. Did I speak up about it? What was going on? No. Joy, did bring up, some of, like Sarah said, like I said, I have not revisited that. Had no idea that I would be
Thank you.
discussing this.
And when did you learn about the meeting between Ms. Youngblood, Ms. Fernandez, and the BEA president on September 26th?
Well, I mean, we got an email that, the board or the, BEA rep wanted to meet, with the board, chair. That email was, it's here, it was dated, So, and on September 25th, there's an email to the Board of Ed. Hi, this is Dennis Petrino, the union president, and I'm requesting a meeting with the head of the border bed to discuss climate issues directly related to actions by the Board of Ed. And it was sent the 25th at 6:57 PM.
And when did you learn of what happened at the meeting?
And we had a couple emails going back, with the board, but, I became aware that it happened on, this is emails that we didn't have access to, I believe around the 28th Sunday the 29th.
And did that email mention who went there?
No.
So did it say that Rosa Fernandez went?
No.
Okay. In any of those emails that you saw, did you see anybody else ask you to go?
Joy asked to attend.
Was she allowed to go?
No.
Okay. And to your knowledge, what is the correct procedure if a Board of Ed member wants to meet with, is willing to meet with the head of the union, particularly for climate issues or board, union, relations? How can that happen under board policy?
It's my understanding that it would go through the superintendent who would facilitate to bring it to the
I'm
board.
sorry, I really can't hear you. You're gonna have to come closer to the microphone.
It's my understanding that the superintendent, that the union rep would speak to the superintendent and would facilitate a conversation with the full board. That's my understanding
Did
of what should have happened.
Did anybody come to the full board and say, I would like to speak,
No.
we need to send, okay.
We did get an email to the full board, on the 29th, specifically stating, what Mr. essentially what I guess transpired or what was said in that meeting. It was sent to the full board. Hi everyone, please do not respond all. I would like to comment, or if you'd like to comment or ask questions, reply to me. I've CC'd Mr. Petrino so he knows exactly what the Board of Ed members are receiving. Please do not respond to him directly. And it just went through, bullet points and see on one side.
So
Who sent that email
Wendy Youngblood sent it to the board
to update the board?
on the 29th, yeah.
So she made sure to fully inform Mr. Petrino, but not fully inform the board.
Well, Mr. Petrino was copied on this, and the board was copied on it. We were not, fully made aware of who attended the meeting.
Mr. Petrino knew, but you didn't.
Do you have a copy of that in the record?
No,
Correct.
You gotta get it in.
What, this letter?
We haven't seen this.
yeah. How do I get it back to you?
I don't need it back.
So may I have this?
Yes.
Okay.
Exhibit A.
Am I done?
And I have questions for Ms. Youngblood, but I can wait until after, like, you think that's people.
Oh, I think I'm done.
Okay.
Thank you.
Right,
Yes,
Yes.
please.
so I have a prepared statement, but I noticed with Mr. Correa, you, started by asking a question, so what is your preferred process here?
I asked because I wasn't sure what to expect, in terms of, I know there's a video involved and I wanted to make sure that I just wanted to know what was gonna happen.
Gotcha.
So, if you have a prepared statement, I'm okay with that. I don't know if you guys, okay.
We're not a court of law.
Yeah.
Understandable. I don't know, is the microphone on? Yeah, it seems.
There we go.
Okay, I think someone had brushed against this and accidentally knocked the mute button, so it appears to be functioning now. Okay, so first to the members of the Board of Ethics and for Attorney Beecher, thank you for the work that you do for the town. To my mind, there are three interconnected parts to this complaint. They've largely been touched upon, but I'm still gonna go through these because they're like train cars. They go kind of in order. So the first is the particular character of Board of Education Policy 1312 and the historical context from which the process for treating those emerged. The second is the issue of, quote, personal interest that leads to a, quote, conflict of interest. And the third is the larger implications of this complaint, especially as it has been brought before this body. So those are the three things that I can address.
Say the third one again, please.
The larger implications of this complaint, especially as it has been brought before this body.
Okay.
Okay, I have a copy for each of you of the Board of Education Policy 1312, and I know you've seen it before, but I'm gonna give it to you anew. You'll see that there's a particular portion highlighted that I think is particularly relevant. Sorry, gosh, that's aggressive. Did you see that? So I'll outline the nature of how we, the current Board of Education, have understood and dealt with 1312 complaints made against board members. This has been a learning curve for us. Because prior to December 2023, when we took office, as far as I can tell, there had never been a 1312 complaint filed against a board member. When this occurred, we had been seated for only a few months, and we were unsure of the legal and practical terrain. Our attorney at the time advised us to take up that initial 1312 and give it public consideration, despite my misgivings. Policies that focus on board members are in the 9,000 series of our policy manual, whereas this is in the community relations section. This policy is meant to address behaviors of district employees. Since that time, and with that mistaken precedent set, we have received several more 1312 complaints, each of which has been dismissed. But not before wasting time money, and other resources. Recently, a majority of board members have recognized that this policy is not rightfully applied to board members. If it were applicable to board members, however, those individuals would receive the same rights to due process as guaranteed to district employees. Those measures were not in place to protect me during that evening in question, so it could be argued that I was denied due process
Denied due process by whom?
by the proceedings.
By these
Right,
proceedings?
so-
Because we actually didn't use that at all.
Well, I just wanna
Yeah,
say, like,
okay.
if we're gonna go like
Yep.
full force with the logic of 1312, saying that it applies to board members, then there are steps that would have been, I don't know, due me that were not in place. Okay, so moving on.
So just to clarify, Ms. Youngblood, you're saying that you didn't get due process at the Board of Education? You're not
Yeah,
making
yeah,
that
yeah.
claim here.
Oh, no, not at all, not at all here.
Oh,
No,
I'm sorry, I thought you meant here.
No, I
because-
didn't mean to mischaracterize that, no,
Oh,
not
okay.
at all. Okay.
Thank you.
So, policy 1312, as Erin alluded to, lays out a two-step process, and this procedural element is important for you to understand. The first step in a 1312 is to decide whether or not to take up the complaint. During the November 20th meeting, I explained that, as you saw, and then summarized the substance of the complaint for the public, as the chair ought to do. To me, this is correct procedure from which a board chair does not need to, should not recuse him or herself. During this first step in the process, it's a proper and reasonable action as a board member and specifically as a chair. The second step in the 1312 process begins if the board votes to take up the complaint. Then discussion ensues among board members until a motion is made to take action or to dismiss. If the board moves to the second step, and if there is a conflict of interest, the relevant board member would then recuse him or herself from discussion. This is how we handled all previous instances of 1312 complaints. Effectively, we were at this time penned in by the precedent set when we were brand new board members. And as time went on, we started to see the 1312 process increasingly weaponized by a small group of residents against the chair and the vice chair. I want you to know that Mr. Korea has fundamentally mischaracterized the substance of the 1312, the subject matter behind it, of the meeting with the union president. Like, all board members here know that our attorney explained to us how that meeting was completely copacetic. There were no infractions, there was no violation of any kind of legal, procedural, or otherwise on my part.
I'm sorry, which attorney are you talking about now? Your attorney said that there was meeting with the union president, there were no
Was-
infractions whatsoever.
None at all, and all
Who was your attorney at that time?
Pete Marr from Shipman, And-
M-A-H-E-R.
MAHER.
He
And all-
advised you, and when was that he advised you?
It was, I don't know the date,
Approximate?
it was in one of our executive sessions. Can I turn around and consult with one of my fellow board members?
Yeah.
Is that?
Do we
call him
and talk to John and
This is-
talk to him?
But this, we received a memo.
Oh, that was
No,
the next executive session, so whatever the next meeting date was after the.
Yeah, but all board members received the same information. This is not, I mean,
And he advised you that there was no conflict for you to meet with the teachers?
correct, it was not a policy negotiations meeting,
That was the one we had.
Do you have that in writing?
not for public consumption. We received it as attorney-client privileged information.
We would need that. We would need to see that.
Okay, I think we can probably get some version of that for you.
Yeah, actually, the version.
Okay, I don't really know the logistics of how that works, but I can pursue that.
Well, you can redact anything that the attorney tells you would not be relevant to proving to the Board of Ethics to be advised that it was not a violation of
Right.
school board policy to
Okay,
meet with the union rep.
Okay.
Anything else that apparently is privileged in that email, you can redact from the version that you submit to this board.
is really a very important document for us.
Right, I just don't wanna forget to do that. Okay, so, further,
We'll remind you.
thank you. I don't doubt that you will. Alright, my vote to dismiss the 1312 complaint was consistent with all my previous votes on whether to take up these complaints. Complaints against individual board members find their expression at elections and not by manipulating the policy manual.
Can I ask a question for you?
Yeah, go ahead.
Were any of those previous complaints against you?
Yes? Against myself and the, vice chair.
Thank you.
Okay, so here's an important consideration for you, members of the Board of Ethics, because you may have to think on this, and for members of the public. When a mechanism allows the lodging of formal accusation of some kind of misconduct against one board member, effectively removing their ability to speak in their own defense, there is certainly a logical through line to a person making an accusation of wrongdoing against two board members. This has already happened twice during my time, against myself and the vice chair, both of the same political party. That same through line could foreseeably extend to an accusation against an entire caucus. The remaining board members would still have a quorum and could deliberate and render binding actions with the authority of the full board. That could fundamentally chill the democratic process on the Board of Education or any other civic body.
Can you just go back over the very beginning part, that when lodging a formal accusation, what did it do to you? What was the impact that you're saying on?
So what I'm saying is that specious 1312 complaints, the way that we had set up our response to them, was effectively removing me from substantive deliberation in my own defense. And all people in certain quarters were talking about were like, recusal. And there was no meaningful investigation into a balanced rendering of what actually happened. And so I started to see this whole process as really dangerous, nefarious. That if two members could be accused of something and then the accusation leads to a forced recusal, well, they'd either have to coordinate like heck to get somebody to ask them the right questions, another board member to do what I'm doing now, come to the podium and, speak their piece. But what's to say if, the accusation, there's no stopping that, theoretically, that you could accuse 3 people of wrongdoing and then they all have to recuse. That's the logic I see.
Is there on 1312, on the board policy 1312, is there any formal procedure for hearing a complaint, presenting a complaint?
Yes, there is. In fact, we've received one in the last few months, and it was appropriately drawn up. It was against a school district employee, and so it was pretty easy to follow the measures there. The complainant has to meet with the administrative at the lowest level,
Mm-hmm.
and then it goes up through there. The steps are outlined, I think, on the first page.
Now, is that for the employees of the
Yes.
Board of Ed, but not for the Board of Ed?
Right.
So if it's against the Board of Ed, is there any specific procedure in place?
Yeah, vote them out next time.
What's that?
Vote them out.
Yes, right,
That's
but
it.
other than that,
That's it. The
So
board can censure, the board can use, I think it's policy 9250, which is about, removal of officers.
yep. Well, I can tell you in a second,
9211.
910, hold on, I'll find it.
Anyway, the point is, there are internal
91110.
mechanisms, but that's to remove an officer.
But there have been procedures in the past where the board comes up with censure with something that,
I think the board has tried very hard not to engage in that.
Right, but there is a procedure.
There is a procedure.
And was
yeah.
that followed this time?
Oh, no, it was never raised.
And
Can you say that more about that? Like,
Censure has been discussed, but not in relation to this.
that's important, I mean,
No, it has to do with another individual.
no, it doesn't matter, the nature of it's just a precedent of, that there has been a process, and whether it was
Oh, yeah.
followed or not this time.
So, yeah, I don't know, like, we definitely have a policy that covers the censure procedure. Okay, so that's why it's important for the Board of Ethics to understand the nature of policy 1312 and complaints brought under it. Now, let's tie in the second part, this personal interest that the Board of Ethics felt might have led to a conflict of interest. So I acknowledge, and it can be seen on camera, that I did not move away from the Board of Education table after recusing myself from discussion. And that, I moved back, but I could see, like, whatever, it doesn't meet the standard. Per Board of Ethics, current understanding of the situation, this is a procedural violation, like, I get that.
Right.
I disagree, however, with some of the Board of Ethics reasoning as described in the findings of probable cause, and so I'm gonna address them here briefly. First of all, I did not have a personal interest in the vote to consider the 1312 complaint. I did not stand to benefit in any material or financial way, nor was my position advanced in this part of the process. Where there's no conflict of interest, there's no need for a recusal as well. The recusal came about out of an abundance of caution and awareness of optics. So I'll just leave it at that. And my vote not to take up the complaint, I see as tantamount to being able to vote for yourself for an officer position. The topic was about me, but it was entirely appropriate for me to vote as a member of the board. I can imagine you, Dr. Carolyn, may have joined Ms. Temple in voting for yourself to be chair of the Board of Ethics. It is a normal part of the civic process.
I would love not to be.
Well, we can have coffee sometime and talk about that feeling. Anyway, the board's probable cause documents stated that I wrongfully engaged in deliberations. So I wanted to address a few points there. I answered the vice chair's question about what should be done in a 3-3 tie. That's a Robert's rules kind of thing. There was no gain, there was no sway of anyone's position on the matter. I also told a fellow board member when she asked me a direct question, I don't think I can discuss that at this time. In due course, a motion not to take up the complaint was made, which resulted in a 3-3 tie. This ended the direct treatment of the 1312 complaint. Next, another member moved to ask me to step down as chair. That motion also failed 3-3, at which time there were no more motions, the discussion was stalled. The vice chair relinquished the chair back to me, and we proceeded with the next agenda item. So now I'd like to talk a little bit about the training the board received on October 30th from Tom Mooney. It was scenario-based. He stressed that, and this is what was really interesting to me, and I'm very clear on it because Stephanie Sikora and I spoke about this at length afterwards. Mr. Mooney, for people who don't know, he literally wrote the book on school law in the state of Connecticut. He stressed that individual Board of Education members know if we have a conflict of interest. I had no financial stake, no material interest in any part of this complaint. Mr. Mooney explained that Board of Education members should not over-recuse themselves. He said it is a mistake to recuse yourself where you know there is not a conflict. Where there is a conflict, yes, recuse. Where there is not, I don't know the exact words, but he said, you represent the voters of your town. When you take yourself and your voice out of deliberations, out of voting, you are silencing the people who voted for you, the people you represent. And I found that to be a compelling point. Finally, so this, I'm in the home stretch here. Part of why I'm here is to stand up against a bully.
What?
To stand up against a bully
A bully.
in the name of our administrators, our teachers, and our staff. The complainant's communications are often pointedly uncivil, clamorous, and instigatory.
Okay, that's, I think this is a dangerous area, because that really,
Thank you.
I think it's a,
I don't know how to, I don't know how to.
Oh,
In other words, the same admonishment would be for Mr. Correa or any complainant or respondent. The focus is on the actual complaint and your response to it, and so far so good.
okay, I think
But
there's
when
a
you go
bloodlust for procedural violation
When
here.
you go beyond, say, an air, a bunch of grievances that are unrelated to the complaint, we get into dangerous territory.
Alright, whereas I can acknowledge the procedural violation outlined in the complaint, I hope the Board of Ethics can see that the version of the events that you initially received in the complaint painted only part of the larger picture. As chair, I acted consistently with past practice regarding the 1312 complaint, including my vote for the board not to take it up. And thank you for your time. I'm happy to answer questions if you have them.
How familiar are the board members with the bylaws of the Board of Education?
That's such a good question.
It sounds like not much.
I think some invest a lot of time in that, and some do not.
How about you? Have you,
Very thorough.
okay,
I mean, the policies are, we are consistently adopting new policies, so it's work that doesn't end, as you guys know. But this is, I have pretty good knowledge.
okay. Why did you meet with the, head of the teachers union?
Because he asked me to.
Yes.
Yes, he said, I would like to meet with the board chair.
But then you took another board member along.
Yes, at the advice of our attorney. He said, don't go alone. And the board member who went with me was not working at the time and was able to fit into the time slot that was available to the union president.
Wait a minute, hold on.
I mean, we're on teachers' schedules.
When the teacher's rep came to you apparently and emailed you to me, did you tell the board at that moment that you had received this email?
Everyone received, we all received it.
It went to
the
Board
board.
of Ed, is that what I
Yeah,
understand?
yes,
It went
yes.
to Board of Ed on the 25th of
Okay, so all
September.
received
September.
email, from the teacher's rep.
Mhm.
Did
Thank you.
Thank you.
any of the board, was there any official action by the board saying, as a group, we think you should do this, either informally or formally? Giving you all-
There was an individual member who said, this sounds like personnel negotiations to me, I insist on going. And I said, this is not personnel negotiations, this is the board chair wants, the union president has complaints, I don't know what they are, I'm going to listen, I'm going to take notes and send them out. And I did exactly that.
Okay, let me go back. I'm trying to find out if the board as a group authorized this visit with the teachers.
I don't know that that is something that has to happen. The superintendent knew about it.
Can I ask one?
You told the superintendent?
Sorry?
The superintendent said okay?
Oh, yeah,
And the board attorney said all of that was okay.
absolutely. As long as the superintendent was informed, yes. I mean, the union president had concerns. I did not know what they were. I went on a listening mission. I took careful notes. I ran them by the union president. Does this look accurate to you? Yes, that looks accurate to me. Typed them up, sent them to the board, with my fellow board members, and CC'd the union president.
Okay, so I want to ask this very specifically. So you get this email that's sent to all the Board of Ed members.
Mhm.
You conferred with the board's attorney on this, about this email?
Yeah, like, I'm gonna go meet with him, and he's like, you should take someone with you, like, don't have this meeting on your own.
And then you also told the superintendent that you were gonna be doing this?
Oh, yes,
And the superintendent said, yes, good idea? Or-
Yeah.
Okay.
How come, I know Ms. Greenstein asked if she could go with you.
Mhm.
Why not?
First of all, she was approaching it from a personnel and negotiations perspective, and I thought it was much less formal than that. Secondly, she teaches in New York State, and I think her travel time would, maybe have impacted, like, when the meeting availability was. Third, that happened to be the week of parent conferences for me, or maybe it was open house or something like that at my own school in Washington, Connecticut. So I had also a narrow window of time, to make this meeting happen.
So, so you chose Mrs. Fernandez,
Yes,
and then someone else wanted to come along and you decided no. Did anyone else ask to come along on this meeting?
no, and the thing is, you just have a little bit of the time, off there. Ms. Greenstein, contacted me pretty immediately, and I said, this isn't a personnel negotiations thing, this is like a listening thing. And so I was planning on going alone, I was talking to the superintendent, and he's like, it's fine with me, just talk to the lawyer. The lawyer said, do not go alone, maybe take the super, and I said, I don't think that's a good look. How about if I take the superintendent? And I was like, I don't think that's a good look, how about if I take the vice chair? Because Ms. Fernandez is the vice chair. So I don't really see how this is, I'm glad you're asking, I guess, but
But
I don't
believe
see
me,
how.
it's critical, you have no idea.
Okay, well, you're right.
Huh. Just trying to think. Did you know what the nature of the conversation was gonna be about?
No,
Okay.
I knew as, the complainant has alluded to, there were, grumblings about, climate, particularly at the elementary school, but I don't, I'm not deeply connected to the elementary school right now, in terms of like having a child there, or like having friends who are teachers there. So I just sort of hear vaguely through the grapevine. So it was gonna be a learning experience for me.
And what role, what reason did you think they had to ask you to go to the meeting, the teachers?
I went to find out.
No. What did they think you would be contributing? There's gonna be a reason.
Oh, why they asked me
Yes.
to meet?
Yes.
So that the concerns that they had could be conveyed to the members of the board and hopefully stop escalating, said concerns.
I'm sorry,
Stop
concerns,
escalating those concerns.
but you didn't know what the concerns were.
Correct.
Concerns could be conveyed to the board.
Mhm.
Why not to the superintendent?
Because I think some of the concerning behaviors were from members of the Board of Education.
The concerns they were gonna convey to you, to the board, were concerned,
About board member behavior.
and anything else that you were aware of in advance? Did you just think this, or you had knowledge of this?
I don't know, because this is my first time meeting the board president, I think. So like, I didn't know.
Okay. Any other questions? Any questions out there?
No, I
I have to give Korea a chance.
Yeah.
Okay.
So, Mr. Korea, would you like to?
Yeah, several questions.
Mrs. Youngblood, stay up there.
Oh, I thought that he was gonna come up and use them. Right,
So,
okay, go ahead.
so does the Board of Education have a grievance and consultation policy that's also linked to the BEA contract?
That's a part of the policies I don't know, so I'm not sure.
They do, and so you mentioned that the head of the union had complaints and that you were going to listen. So how is that not either grievances or a request to consult?
Yeah, I understand what you're saying. I think that it could become, I think the word complaint, can have a legal meaning and then it can have a vernacular meaning. And my understanding, well, my experience in this situation is that this was the vernacular meeting, like, we're really tired of this, we want people to knock this off.
So would you
This-
call it, they wanted to grieve or consult if you had to pick one of the two?
I wouldn't, I would say he wanted to let me know what was on their minds.
Is there any policy that says, if you wanna let me know what's on your mind, how to interact?
I I don't, your question is worded in a way that's hard to answer. What exactly are you asking?
What are the appropriate ways for the union president to interact with the board, any member of the board?
I think sending an email, giving a call.
According to the grievance and consultation policies, it is to go through the superintendent, and the superintendent goes to the full board.
Okay,
Did you do that?
yes.
You went to the full board?
Well, through email, yes.
And did the full board take an action to authorize you to speak to the union rep?
No,
I've already asked that question.
You gave the, Mr. Petrino in the email that you responded, you gave him your phone number. Did he call you?
is that Jermaine?
Yeah, I mean,
Yes.
What was the discussion?
Well, we had several. Part of it was me, summarizing my notes, saying I'm gonna send this to you in an email, does this sound okay? Actually, no, we might have just done that over the phone, like, here are my notes, this is what I'm gonna put in the email to my, fellow board members, does this sound accurate to you? Cause I don't think I committed that to writing.
Was anybody else on the call?
No,
Why didn't you list the attendees in your email to the
for
board?
heaven's sakes. I don't think that's relevant,
Well, it's a recap of the meeting.
okay, I didn't do it.
Why didn't you take, Joy Greenstein with you to the meeting?
Because as I
I'm sorry, what
already,
did you want?
you already asked me this question.
I did.
Okay, what was the rush to have the meeting right away? Why couldn't you wait until, Joy Greenstein was available?
That was not my priority, it was her feelings on this.
I'm not sure this is relevant, your
That
language.
sounds like a lady.
You were really,
I mean, it's relevant as to why she wouldn't accommodate, from a time perspective, Joy attending the meeting.
No,
she-
that's already
she
been
answered it
addressed.
already.
I answered that already. Anything further?
Yes, you mentioned that you have voted whether to take up a 1312 against yourself in the past.
Mm-hmm.
What was your vote?
I voted no against, every 1312, complaint against board members.
No, for yourself.
What do you mean?
What, there were 2 complaints against you prior to this particular
I
one.
think maybe more than that.
There were 2.
No,
Prior to this one, there were 2.
I think more.
Just to clarify, she said she voted against every single one, so that would include any that were against
She
her.
voted abstain for the prior 2.
Oh, for heaven's
So
sakes.
it's relevant that she'd abstain from the prior 2, but vote no for this particular one.
I think my understanding of the best way to move forward with these has crystallized over these past few months. And so, ways that I might have acted in the beginning are, if they've shifted from abstention to no, it's because I'm more secure in how I feel about these issues, and I think the majority of the board is as well.
Does the public do the policy 1312 to have a complaint about the actions of the board?
Could you repeat that?
Has the board publicly stated that the public has the right to complain to the board, whether they use policy 1312 or not?
You know, I know that in the first months when this happened, we had some deliberations about that, but we were sensitive to the public, and Mr. Fichetto has really been a champion of this, that we feel that the public's complaints deserve to be aired, even if they are ultimately found to be things that we don't move on. But with the way that, and I can agree with that, and that's what moved me in the beginning to hear the initial complaint in March of 2024. But as we've seen this play out, we've recognized that this is often more about like gotcha moments about procedure or people's flawed understanding of what actually happened and positing that incomplete understanding as the absolute capital T truth. And it's not been a fruitful use of board time.
You stated you need, to be able to defend yourself, you needed to be at the deliberation table. Why couldn't you have answered questions from board members from the podium?
It has not been our practice. I guess I could, but that would require a degree of orchestration. I think that we just were not even envisioning, like prepping questions and rebuttals, and we just didn't even go there.
So
Good jobs.
moving 25 feet requires coordination?
I'm gonna pretend that that's a rhetorical question.
No, I'm asking, you said
Well, no,
I asked why you couldn't go to
she
the
already
podium.
answered the question, and you're just asking it a different way. She already said that maybe going forward would be different, but she answered your question.
Who attended the meeting with, Ms. Petrino on the 26th?
Oh, I think
I'm sorry.
we heard about that, the meeting, yeah.
That's irrelevant to our purpose here. Is 1312 specific, does it have specific reference to grievances or complaints
I think
against?
it's right in front of you.
I know, but does it have specific references to complaints against Board of Education members?
No.
It's for the community,
Correct.
so I'm not even sure why it's relevant here,
We, ask ourselves that frequently.
because that would be, behavior would come under this
Sure.
group.
But we, as I said earlier, green as we were, and with the advice of our attorney, who's like, yeah, well, the public really deserves some kind of way of complaining, you know, it felt hard line, it felt like I hadn't earned the right to say, well, they can just vote us out. You know what I mean? That didn't feel very good faithy at the
That's actually
time.
never a good thing to say.
Right, right, no, I understand that, it does sound cynical, but we've just lived it for a year and a half, and seen what it actually looks like in terms of board time and bandwidth, and this is not the way for us to do our jobs and help move the district forward in ways that are
Thank you.
meaningful. Are you,
I have one more question.
Go ahead.
Given the concern with the time and expense, you know, when it became, you know, known that potentially this could be an issue, why couldn't you just come out and say, I shouldn't have been at the table? Or I should have conferred with the board as a whole.
so one of those questions has merit and one of those questions does not.
It has both of them have merit.
Well, I'm only acknowledging the first one. I think it's worthwhile to go through this process. It's not a fun use of time, but I don't want to have our body, the Board of Education, pushed around over procedure. And I'm not perfect with it. I'm learning aggressively, have been, and I will probably make mistakes here and there in the next, year and a half. Anybody who's called to direct action, who puts themselves in a place where specific knowledge is expected, will occasionally make mistakes. I mean, I have another job, and so I know the policies pretty well. Statutes are, I had not read the Code of Ethics. Now I'm up on it more. I know the charter well, so some things are gonna slip through the cracks. So I may see you again here, we will see. I don't know.
And how many times were you reminded of your obligations to recuse yourself throughout public comment and email?
There are some things I don't count.
Yeah, may I ask, are you referring to recuse ever, or recuse at a meeting?
Just just in general obligations.
Okay, because
the Code of Ethics.
we're focused on
Yeah, that's-
November.
That's an unfair question. If you're talking about the particular night that we're talking about in the complaint, then she can respond to that.
Yeah, okay, all right. Board members, any questions?
Just whether Dr. Youngblood has other people she wants to introduce. I didn't see any on the witness list or,
If she has any questions for Mr. Correa, because she never went back if she wanted to
No.
probe him.
I didn't ask you that?
No,
Oh my God, okay.
could you just sense it?
Huh?
I have no questions for him.
Oh, okay. These
So
are
I'm
questions
just
for-
trying to be careful here that everybody gets an equal
Absolutely.
process.
Thank you for
we
bringing that
appreciate
up.
that. We're all learning procedures.
No,
I am.
okay. I don't wanna move to the next part because it's a totally different part, and we have to get out of here because other committees are coming in. I'm thinking, that this might be a good time, I hate to say this, kiddies, but to, adjourn this meeting and come back, and then it'll be just the board talking about the information that we've received, that we've requested.
Yeah, just be sure everybody's done. And then close the hearing officially, close the public hearing portion, and
Okay,
then you'll go into deliberations whenever you want.
okay. Yeah, that's actually where we are.
Yeah,
Is that okay?
yes.
All right. So at this point then, we'd like to close the public participation, section.
But as long as no one else,
I just have a question about
Yeah.
something that occurred. You had asked for a piece, some information from
Yes.
me. So, does it close after that, or that just gets shared?
Does what close after?
remind us what it was.
You
So-
want the memo from, our board attorney?
Right,
You want something in writing, having to do with the September 26th meeting and, whether or not that,
And you could redact out the part that
whatever, I
the
mean,
attorney,
I'll probably need to circle back and get clarity on what needs to be redacted.
that would go to the town clerk in a
Okay.
sealed envelope, for us. It's something we asked for at the hearing.
Okay.
Yeah.
And that you talked about.
Okay.
So I would just like to see it and have a chance to respond.
to make it,
Yeah, I can.
yes,
No, it's
you
not.
need to consult with the board's attorney.
Yeah.
To explain exactly what we've asked for, which is what I asked for, which is a portion of that actual correspondence from the attorney that said it was okay for you to meet with the union representative. And you said, well, it was marked confidential,
Yeah.
lawyer, attorney-client privilege.
Yeah.
If whatever is privileged beyond the one sentence that says it's okay for you to meet with
Okay.
the union official, if something else in there is confidential,
Okay.
that can be redacted and just send the portion that identifies that it came from the attorney to you, or whomever, including you, and the portion that said it was okay, that we can see. If it's easier, you and or the board attorney can email it directly to me,
Okay.
and I'll make sure that board
Great.
members get it, and it'll go into the public file.
It may not check the exact box that you're looking for, because it may be about whether or not it was qualified as a personal negotiations meeting, but, I'll send you what I have, or what I'll get.
If there's a problem with producing it,
Okay.
would you ask the attorney to call me directly?
I will.
So if it's going into the file, it has to have the reason, I would say. And I wanna see it and have the opportunity to respond.
I think that's fair.
I'm sorry, say it again?
Unless the opportunity to respond
Yeah,
to
so
the document.
If it's just you can go talk to the, union rep and it's all redacted out and there's no reason, then it's not really evidence, right? There needs to be rationale, and then I wanna see it and have a chance to respond.
Well,
Because he's a
you're not
lawyer
gonna-
doesn't mean he's
You're not
right.
gonna be able to see the part that the attorney has made it a decision that it's privileged.
No, yeah, I
But
shouldn't
if
say
there's
privilege
something that
part, but
can
the
be-
rationale based on the policy should be in there.
We're gonna, whatever we get,
Yeah.
you will see. And we can reopen the hearing on the very small issue of whether you wanna ask any questions only of Ms. Youngblood related to what that document, redacted or unredacted, says.
Yeah.
The board is not gonna open up the whole hearing.
No, I just wanna be able to
Rehash
respond to the
everything that
rationale.
we've heard so far.
I just wanna respond to the rationale that the attorney had, that she could meet with the union president without going to the board.
If we see that. Understood.
Okay. Alright, so, we're at the meeting now, at the point where the board would be taking over, and that you would just be here to listen. So we're gonna, I'm gonna make a recommendation that we close the public portion of the hearing, of the complaint hearing.
I second that.
Wait, did I need to say anything more in that complaint?
No.
Huh? Okay.
You're just closing the hearing section and then you can adjourn to another meeting date.
And the
Deliberate.
adjourn to, another meeting date, to continue with the, Board of violations on the matter, Board of Ethics, I'm sorry,
I know.
I do that all the time.
Yeah.
Okay, so I made that motion and you
Second.
seconded, thank you. Any discussion?
No.
Okay, all right, so we've adjourned the meeting
All
at,
in favor?
5,
Aye.
all in favor, all in favor, thank you. Unanimous. And we then have adjourned the meeting at 5:26. And I'm just gonna briefly try to set up another time for our next meeting. You can listen to us try to figure this out.
Or we can leave,
Huh?
or we can leave?
You can
Yeah.
leave.
Okay.
Thank you for your service. Thank you for your time.
It does.
Yeah, so
You have to make it a rush.
we have to wait to get documents at the time, right?
I have a
I don't
feeling-
know how we're gonna react to it.
Okay,
No
so-
jacket?
Sweating.
And
Oh, this is, or this is.